So one set of cases which is on ILDC and which is particularly interesting, I find, is the string of Italian cases on the immunity of foreign states in the Italian courts. So the question basically is that Germany committed war crimes during the Second World War. Claims were made a few decades ago. Germany claimed immunity from the jurisdiction in Italian courts, and the Italian courts then said these are crimes against humanity, no immunity applies for Germany. And Germany was convicted to pay compensation. The matter was brought to the International Court of Justice in The Hague, which then said that Germany was entitled to immunity. And the matter was then relitigated in the Italian courts, which went back and forth in all directions, but eventually came out on the point that the Italian courts would not follow the International Court of Justice. So this is a very, and so would not uphold the immunity of Germany. So this is an extremely fundamental question for international law, whether foreign states have immunity and whether a domestic court should follow a judgment of the International Court of Justice. So there's a whole string of cases, both preceding the judgment of the International Court of Justice and following the judgment. And having them together in ILDC, where you can link from one case to the other, with commentaries that explain how all of these cases are related, because this is fairly complex stuff of multiple courts of different jurisdictions. And then being able to see this in the light of the ICJ judgment, for me is an invaluable resource for scholars and for practitioners. Yeah, so this was a very surprising and interesting case. So a Dutch NGO brought a case claiming that the Netherlands violated its obligations in part under international law because the emissions were in excess of what was agreed in the Kyoto Protocol. The court then, first of all, accepted that the NGO could bring these claims, and then held that, and the court referred actually to the scientific reports of the IPCC, referring to the long-term effects of climate change, that the 25 to 30% percentage that the government was now aiming at were not enough, and that the government should do more to comply with its international obligations. And it actually ordered the government to achieve a particular percentage reduction of emissions of carbon dioxide. So this was quite surprising, because until now it was thought that the international law of climate change was basically an interstate affair, and that the obligations were not drafted in a way that the domestic court could adjudicate the claims on that basis. This court nonetheless felt that based on the scientific evidence and the nature of the obligations, it could determine that the Netherlands acted in violation of international law. So this is a case with potentially quite far-reaching implications. Certainly if other courts in other states would follow a similar approach.
There's a whole string of US cases dealing with the Alien Tort Claims Act or Alien Tort Statute, which is very valuable because it shows this immense development in US jurisprudence, whether there are domestic remedies available for violations of international law, which of course is something very peculiar because of US legislation, but on a broader basis, of course, also needs to be compared how are other national courts dealing with that. And we are increasingly also including cases from other jurisdictions dealing with very similar problems, whether there is something like a domestic action in damages caused as a result of a violation of public international law. So that, I think, would be also a very good example of very important cases dealing with fundamental questions of violations of international law, attribution, state responsibility in all kinds.
Yeah, one set of cases that I find striking are the Israeli cases dealing with issues like targeted killings and demolition of houses of people who are ascribed as terrorists. I mean, there's something in the public debate on Israel and the conflict with the Palestinians as being a lawless conflict dominated totally by the inequality of the parties. But the case law of the higher Israeli courts, even though you might disagree eventually on how they come out, actually shows that international law is used and is very, very relevant to the balances that eventually are struck between the interest as is perceived on the side of Israel and the rights of the individual Palestinians. So this case law shows a sort of legal domain to the entire debate, which often is missing from the general public debate on the conflict in Israel. So, I mean, 10 years ago it was virtually impossible to research these type of questions by comparing judgments from different states, as long as they were not originally written in English. So the ability now to read these holdings, at least, and sometimes judgments in English, is again, for practitioners and scholars alike, a very useful and important tool for research.